Good morning, everybody. I'm Jeremy Hyden, Executive Director of the North Shore Business Improvement Association. Thanks for joining us for today's Power Hour Business Development Seminar. Our President, Bryce Herman's on the call, and as always, Bryce, we'd love to have your words of wisdom to start us off.
You bet. Thanks, Jeremy. I just want to thank those that are joining us tonight and those that are joining us by tapping into the resource online. And I look forward to this morning's session, but I do want to take the opportunity to thank both David and Lisa for their time and their wisdom that they're going to share with us today. So with that, I'm going to turn it back to you and Lisa and David. Thank you.
Perfect. Thank you, Bryce. Employment questions are being asked this week, which will significantly impact the way that business is conducted, how employees are recalled, what rights each of the two partners in the employment relationship have. And so we've really pulled this together to answer some of those questions. So David Hughes is a business and employment lawyer with Forward Law, who also teaches business and employment law at Thompson Rivers University. Before co-founding Forward Law in 2013, he was senior legal counsel at BCLC, and as a small business owner, he relates to and enjoys working with other entrepreneurs. Lisa is a human resources consultant and has worked for and consulted with complex organizations, including private sector, startup, development projects, global resource, public sector, crown corporations, non-union and unionized environments, and has provided strategic and operational human resource management and project management on a large organizational and change initiatives. She's got 20 years of progressive HR experience in all aspects of HR, including infrastructure, policies, procedures, practices, leadership development, and building high-performance teams, organizational development, employee engagement and culture, employee and labor relations, total rewards, our organizational and job design, recruitment, talent management, and in her spare time, she does webinars. So welcome to our two speakers. I turn it over to you.
The hour is now over.
Perfect. Take it away, David.
Okay. Well, thanks very much. I just actually was doing some calculations there, Lisa, that of your 20 years, I've probably now known and worked with you for about 12 of those 20 years. So I think
you have. Yeah.
It's been a long time now. Yeah. Okay, well, thank you, Jeremy, for the invite, and welcome everyone. I can see a few of you there, Chris, Terry, Patty, in the audience, and hopefully if you're joining this as a webinar, welcome to you as well, and thanks for taking the time to tune in. So I do have a little bit. I'm generally not a fan of slide decks, but I do have a slide deck for this one because there are a few important points that I think people need to be aware of, and I had a slide that was right on topic for this. So I'm going to just start by trying to share my screen here. So kind of boring, like every lawyer, I have to give you this disclaimer right at the start, just to say that these slides are providing legal information only and shouldn't be relied upon, and you should always seek legal advice that's specific to your exact situation. But why are we here? This is the slide that I really wanted to show people, because when I listen to the news and I hear people talking on the streets, there's a lot of misinformation out there. And the problem is because we have such a complex set of laws in Canada, and specifically in Kamloops, that you might meet two people on the street who might have two very different situations that apply to them. So this is the slide that I really wanted to share with you. These are some laws, workplace laws, that apply to employers located in BC. And what I want to show by this slide deck is that if someone talks about privacy law prevents this, or privacy law means that I have to do this, there is no single privacy law. So you could be someone in Kamloops and you could have one of 4 privacy laws that apply to you, depending on whether you're provincially regulated or federally regulated, whether you're private sector or whether you're public sector. And the same thing applies, maybe not 4 different, but for human rights. So if you're provincially regulated, the BC Human Rights Code applies to you. If you're federally regulated, the Canadian Human Rights Act applies to you. And there are some differences. There are profound differences between those 4 privacy laws. And particularly what we're going to talk about today, employment differs. The employment laws differ, and the employment laws differ quite significantly, in my view, actually, between the BC Employment Standards Act and the Canada Labour Code. So my point being is that if you meet someone on the streets in Kamloops, if they work for Scotiabank, TD Bank, CN Rail, or to Kamloops to Secwepemc, they're going to be governed by the Canada Labour Code, and all the laws under that piece of legislation, including the new ones that are coming around COVID, are different from if you meet someone who works at, say, Interior Savings Credit Union or Red Beard or Forward Law for that matter, right? Because we're provincially regulated private sector. And what concerns me is that when people listen to the news and they're listening to commentators talking about, well, you're allowed to do that, employers can do this, employers can do that, it differs. There is no uniform legislation across Canada that says what employers can do in a time of COVID. And the changes, there have been changes made to both key pieces of legislation, the Employment Standards Act and the Canada Labour Code, and they're quite different. So that's what I want everyone to appreciate, is that before you go and act, don't act on the basis of like something you've heard on the street or what your buddies told you. Actually understand what are the pieces of legislation that apply to your situation, because it might be very different from what applies to your neighbor. So my focus today, and I'm not going to go on for that long, is I think most people who are watching this are going to be governed, they're going to be BC private sector employers and employees. And so mostly I'm going to be looking at the laws on this side, in particular the BC Employment Standards Act, because I think that is going to apply to most people. So the key changes to that act, and let's get right into COVID. I'm just linking to the act now, is that there is COVID protected job leave that has been introduced under section 55.12. So I'm just going to scroll down to that. Sorry, 52.12. So this is the relevant section of the Act, which says that an employee is entitled to unpaid leave for the period in subsection 3, which is now as long as required, in relation to COVID-19 if any of the following applies. And this is what I think is really interesting, because this is very different in BC for Employment Standards Act than under the Canada Labour Code. So if you have been diagnosed with COVID-19, and if you are acting in accordance with the advice of a medical practitioner, nurse practitioner, or registered nurse, then you have indefinite unpaid leave, and you cannot be terminated because of that. That is very different, though, from under the Canada Labour Code. The Canada Labour Code does not say if you have been diagnosed with COVID-19. It says if you are unable or unavailable to work for reasons related to COVID-19. So you can see immediately that there's a huge difference between the law that applies to you if you're working in a federally regulated business v. provincially regulated. Now, the key here is that you get your unpaid leave, and so you get to go on CERB, basically, for an unlimited time if you have been diagnosed with COVID. Here's the kicker to this, though, is that if requested by the employee must provide reasonably sufficient proof that a circumstance described in subsection 2 applies. So you have to give proof of the fact that you had it. But 5 here that I'm highlighting says an employer must not request, and an employee is not required to provide a note from a medical practitioner, nurse practitioner, or registered nurse for the purposes of subsection 4, which does mean that this is actually going to be a little bit hard, I think, to enforce, because it comes down to a lot of trust. Because if you have an employee who is refusing to turn to work and says, well, I've been diagnosed with COVID and my doctor or my nurse has told me I can't come back, there's nothing that you as an employer can do. You can't at this time require them to provide a note. So that's the important thing that I think to recognize there. Having said that, let's say you have an employee, though, who isn't trying to say, I'm relying on this section of the Act. They just say to you, I've been temporarily laid off and I'm getting CERB and it's really good, I like it, and I just don't feel safe coming back to work. Do I have to come back to work? This is something that's coming up, a question that's coming up a lot. And in my opinion, I think generally the answer is yes. An employer has the right to make reasonable requests of an employee. And a reasonable request is, okay, COVID is being brought under control in BC. We're starting to open up. Business is picking up. I need you to come back to work now. That's a reasonable request. And then if an employee in general refuses to submit to a reasonable request from the employer, they can be disciplined in stages right up to potentially even termination for cause if they continue to refuse to comply with reasonable requests. The big thing, though, that I need to make clear is, well, is a general feeling of I don't feel safe at work because of COVID, an unsafe workplace? Because, and I want to switch here, an employer or an employee always has the right, they always have the right to refuse unsafe work. This is the issue. So let's say that an employee comes to you and says, I don't want to come back because I'm scared. I don't think that there's sufficient protections in place for me. Well, this is where the occupational health and safety regulation from WorkSafe comes in. So they say, I believe that I'm going to refuse to come back because it's unsafe work. This is the process that employers need to follow. The worker has to immediately report to the employer that this is unsafe work. The employer must immediately investigate. Now, if the employer determines that you or the employer has followed all of the procedures set out by WorkSafe BC, like educating people on hygiene, like encouraging the use of masks if you can't keep people 2 meters apart, like putting in protective barriers, the employer can come back to that employee and say, I haven't identified any unsafe conditions. You have to return. So at that point, you have two outcomes. The worker can agree that it's no longer unsafe and return to work, or the worker can say, it's still unsafe, I don't believe it. In which case, you have to investigate yet again, and the employee can have a representative. Again, it's the same process again. If you go through and you find, I've taken all the measures, there aren't any unsafe conditions, you can say, you've got to come back. And the employee either comes back, or finally, if they still say it's unsafe, then they have to immediately notify WorkSafe BC, and WorkSafe BC will come and do an investigation. I think the key point is that WorkSafe BC has actually put out really great, handy advice for employers about these are the steps that you need to take to make your workplace safe, depending on if you're an office or if you're a retail environment. And if you're meeting those steps, you're likely going to be found to be safe. The key thing is that you cannot terminate an employee while you're going through this investigation process if they return. If they're complaining and saying, I don't feel safe coming back to work, and you haven't gone through this process, you can't terminate them, because then they're going to have a claim against you. But if you've gone through this full process and your workplace has been deemed to be safe and they're still not coming back, then that is a refusal. That's a breach of contract on the part of the employee, and ultimately they can be terminated for that. So I think that's the second important point to realize, is that a general fear is not going to be an unsafe workplace, and that if you can prove as an employer that you've met all the requirements of WorkSafe, you're probably going to be fine, and an employee must return to work. What about changing hours? What if an employee, you want the employee to come back to work, but the employee feels like, well, I'm going to get more money through being on CERB? Again, that's a really interesting situation, because unless you have an employment contract with that employee that says it's a part-time contract and your hours will vary, then you might be in a problem. Because if you had a full-time employment contract, in writing or not in writing, with this employee beforehand, you cannot require that employee to come back part-time without that employee's consent. Because if you did, that might actually be what's called constructive dismissal, because you're materially changing the conditions of that employee's contract without their consent. So you cannot go from having been a full-time employee to you as an employer saying, but come back but only part-time, without the employee's consent. They do have a legitimate ground to say, no, either you bring me back full-time or you don't. Now, if they were a part-time employee beforehand and they worked hours that varied and they were paid by the hour, then you can probably bring them back part-time, because you're not breaching the contract, you're not doing anything different. The question that Jeremy had asked about CERB is, well, what happens? And you're right, I think everyone knows that under CERB, you are entitled to this for 16 weeks if you've been laid off or lost your income because of COVID, and you can earn up to $1,000 a month. But it does mean that there's going to be this uncomfortable area for an employee where if you're a part-time employee and you earn less than $2,000 a month from your job, but more than $1,000, you're a little bit stuck. And that's perhaps good news for an employer. You can require someone who's a part-time employee to come back and work for you. And if it happens that they then end up earning over $1,000 a month through your income, they are going to likely lose their ability to claim CERB. So in reality, it's one of the things Jeremy was talking about before we got on the start of this call. You might want to just manage their hours and just be careful about making sure that they're not, until you can offer them, sufficient employment, they're not working more, earning more than $1,000 in a month, so that at least they can continue to get their other benefits. Those, I think, were the three main points. I think we'd agreed to divide this up about 15 minutes each. My slide deck, if you want to go back to the original slide deck, I won't go through it. There have been some other important changes to the Employment Standards Act, not related to COVID. I deal with those in my slide deck, but I think
David,
yes?
Sorry, I do have a question for one more scenario. What if you have a part-time employee that refuses to return because they can't find daycare because of COVID?
Under the Employment Standards Act, there is an exception for they get unpaid, job-protected unpaid leave if they have to care for children. Let me find the exact wording of that though, Chris.
I reference it in mine. So Chris, basically employment standards indicate if you are caring for a child or another person that meets the eligibility, it might be like a dependent person. If school closures or daycare closure, it does fall under the protected leave under employment standards.
Yeah, that's in section, I couldn't find the screenshot, but it's under section 5212. So yes, caring for kids is an exception. So they are entitled to.
But it is unpaid leave.
It is unpaid.
So really, to David's point, I think COVID-19 has really created a lot more awareness for employers on a lot of the legislated policies, because it's been brought a little bit more to their attention, whether it's BC Employment Standards Act, whether it's WorkSafe, the Privacy Acts, but other provincial and or federal legislation, as David commented. So having core policies in place is not only required by legislation by employers, but more importantly, I think it really helps employees and employers to develop that mutual understanding within their workplace of the requirements, the expectations, and even the values and mission of the company. So it really supports and can reinforce the culture that they're trying to create, that shared accountability, and provide information for both parties on each other's roles and responsibilities. So having sound policies that's shared with employees that are signed off and reviewed regularly also helps to potentially protect the employer in the event that there is a breach or a termination. If you can show that you've been working within the policies and done all the right steps, it can really help protect you as the employer. And I know David can speak to that more on the legal side, but over and above that, I think ultimately now, more than ever, just caring for the well-being and health and safety of employees in your workplace is just an expectation and requirement, not only by law, but just by employees, and it makes for appropriate engagement and helps your business, bottom line. So I'm going to talk a little bit about policies that should be considered, mostly in light of COVID, but I will touch on a couple that David has talked about with employment standards that might be relevant. And it's not cut and dry. I know policies in general, people are like, oh, I don't want all these black and white policies. How I view policies is really about it being really principle focused. You want to allow enough flexibility for you to manage your business and lay out the expectations. So not every policy has to be black and white, because there's a lot of gray when it comes to working within your environment and working with people. So even before, and this is probably a good one for David, so and I know he'll agree, but policies are very important, but fundamentally having a solid employment agreement that's well thought out is really important, and it considers the employment relationship, your legal obligations, and can protect, again, the liability for the organization. So it's your legal contract. I always recommend putting termination language in so it limits the liability of the employer. And one thing that COVID has really identified, and David, tell me if you agree or disagree, but it really identified that many employers didn't have layoff provisions. So during this pandemic, of course, layoffs had to happen. So you need to have employee agreement. And if it was in your employment agreement, it made it a lot easier than some of the steps employers had to take during this unexpected pandemic. So I'm not 100% sure that because layoffs happened and businesses had to respond and react so quickly, that maybe all the employment standard requirements were met in that regard. And that's starting to show up as they're trying to recall employees back with some of the questions.
Yeah, Lisa, that's a great point. Actually, if I could jump in on that, it isn't something I talked about, but yes, there was a lot of just basic belief that, well, I have the right as an employer to temporarily lay off an employee. And in general, in BC, under the Employment Standards Act, that's not the case. You could only lay off someone temporarily, one, if they consented, two, if it was in their contract, which is a way of consenting, or three, if it was customary in your industry. So I think a lot of employers just assumed without knowing that they could temporarily lay people off. And in fact, they probably couldn't. And so actually having that in your contract is one of the ways in which you can do it. So that's a great tip, Lisa. Yeah.
So that's something I'm recommending to employers now, and having good termination language is also good. And again, as David mentioned, I'm going to focus on BC. I'm going to focus on private sector or businesses that are more provincially regulated, not federally regulated, and not unionized as well. So primarily the BC Employment Standards Act, WorkSafe BC, and the BC Privacy and Information Protection Act. So employers really should have a policy or handbook manual that, as mentioned, is read and understood, and employees are required to sign off on some of those foundational requirements. And that's going to look different between companies and industries based on the requirements. But as David mentioned, really the Employment Standards of BC covers the basic standards of compensation and conditions of employment. So as of last year, with some of the changes that David didn't touch on, it is now a requirement for employers to make employees aware that they are covered under the Employment Standards Act and they have rights under that. So that needs to be considered. So I'm including that in policy manuals now as a core kind of headline right at the very beginning. And then of course it includes hours of work, overtime provisions, leaves of absence, including the new COVID, stat holidays, wages, vacation, etc. So I won't also touch on that, but now with COVID, the new COVID related leave, as David spoke about, it is a job protected leave, so employers must have the ability to provide that leave on an unpaid basis. And I've got the language here, Chris. As David mentioned, it's for an employee who's been either diagnosed with COVID or is in quarantine or self-isolation. The employer has directed the employee not to work because they may have concerns that the employee was exposed and could expose their workforce. And the employee is providing care to an eligible person, including children, meaning a closure of school or daycare, or if an employee has traveled outside the province. So I think it's important to have a policy manual that touches on the Employment Standards Act and some of those general areas. The other one that was new last year that was introduced that I think is important just to highlight, because employers probably don't realize, they can also now get recovery of wages if they've overpaid an employee or have done a payroll advance. So there's language in employment standards that was introduced last year. So moving to WorkSafe BC, of course, they have a number of policies that are more important than ever before. The first one has been in place since, I believe it was 2013, bullying and harassment. And still many employers are still being educated that that is a requirement to have bullying and harassment policy for their workplace that outlines the reporting procedure and training of new employees at hire and once a year. So I think that's important to reinforce now, because there's been a lot of anxiety and fear from fellow coworkers, colleagues, and people maybe don't have some resiliency and as much as they have had in the past. So making people aware of the appropriate behaviors and respectful behaviors in the workplace is still very important and critical. Employers are required to develop a COVID-19 safety plan, and as part of that plan, it outlines the policies, guidelines, and procedures in place to reduce the risk of COVID-19 transmission. The policy in WorkSafe suggests that frontline workers, or if you have a joint occupational health and safety committee, and managers must work together. So it needs to be a collaborative approach to identify the protocols that are appropriate for your workplace. So the plan must be posted as well at the work site, and employees must be trained on those protocols. So it's going to differ by industry. Again, hospitality, restaurants are going to look different than an office environment, but it really needs to include who can be at the workplace, how you are addressing illness, and how workers can be kept safe in adjusted working conditions. So given this adjustment under WorkSafe, employers have now moved a lot of their workforce remotely, and or even working alone potentially to protect the transmission of COVID. And for those remote working, the home is considered to be an extension of the workplace, and the Workers' Compensation Act and all of the occupational health and safety regulation does apply. So in that manner, if you do have remote workers, you must have a policy that addresses remote working. And it needs to include things such as the process for employees to assess their work hazards at home. So do they have the setup for to work safely, and what are the potential hazards? And it's the employer's responsibility to still mitigate those even though they're working out of their home. So the policies also needs to include protocols for evacuating the workers to a safe location if needed, and who should be contacted in an emergency, safe workplaces, and how to report any work-related incident or injury. So of course they're still covered by WorkSafe BC. Communication protocols and check-ins if a worker is working alone. So how are you ensuring that they're kept safe? Ergonomic considerations, as I mentioned, so do they have the right desk setup? So I've been on Zoom calls with people and they've literally been working out of their bed, you know, on their laptop, and I've had people have nightstands with pieces of plywood and a whole bunch of different situations. So that could create risk if they're not ergonomically set up, and ultimately affect a claim against you as the employer. And other safety considerations, so potential for electrical safety, slips, falls, and so on. And as I was thinking about WorkSafe BC, for many businesses in the past, there's been a lot of travel required. I think that's one of the trends that we'll see that David and I will talk about. But if you are requiring people to travel in the future, what are those policies and procedures that should be developed in that regard once travel continues, and what does that look like to ensure your people are safe? So really many considerations now for employers to ensure the safety and well-being of their employees, whether they're working from home or whether they're working in their office. And then just to touch on the Privacy Act, I think this is one act that may get overlooked sometimes, primarily for smaller businesses. And I'm not considering the larger businesses that work under public sector or crowns. Their Privacy Act is different. But for smaller business or for private sector, it's the BC Personal Information Protection Act. And organizations have a responsibility to protect personal information of its employees and the public, including your company clients or customers. So now with so many employees working remotely, it's been highlighted now, because we want to make sure that you've got policies in place that really protect that privacy. And with people working on their personal devices, working from home, information being transmitted in different ways, it's still up to the employer to ensure that those safety measures are taking place. So a policy in that regard might be a work from home policy that defines the employee responsibilities to protect company and customer data, how to secure information in their remote workspace. So do they have a filing cabinet if it's paper files? How to report a breach? Are files encrypted? Is it required that you're using a VPN or a secure network? So it's really important to understand the requirements so you are protecting personal devices and or personal information of your employees and your clients. I know this act is getting reviewed. I sit on a provincial board, and they're asking for input as well. So they're looking to update and get this act, I think, more current as well. So, you know, and are people allowed to download and store company information on their personal devices? I think that's a big piece. And in some cases, people are using personal email addresses. So how do you ensure client data is protected when people are using personal email addresses? So those are a few considerations I've outlined for core policies needed kind of over and above the policies that you may already have in your workplace.
I think our next thing on our agenda was we talked about potential issues in the next few months, including rise in constructive dismissal cases, possibility of discrimination claims. So this is an interesting one because as we've sort of all talked about the fact that we're all coming back to work over the next little while, there may be some conflicts in the workplace. So what are some opportunities for us as employers to deal with some of those conflicts, and what's our best methodology for dealing with those kind of potential issues that can become much, much larger if we're not cautious about how we deal with them?
So maybe I'll start, and then David, you can kick in your thoughts. But I think with anything, and this is sort of my philosophy overall, it starts with communication. You need to be talking and involving your employees on the situation. Be transparent. Have open dialogue. Understand their concerns. Every employee's situation is going to be different. There's going to be people at home with trying to work from home while they're homeschooling, whether they have a spouse also working at home. And then there's going to be others that are, working from home, they have no distractions and it's easy. So you really have to work with every employee and understand their situation and try to mitigate that appropriately where you can. David, do you have any additional thoughts?
Yeah, specifically, I think the thing that I'm seeing and employers should be aware of is under the BC Human Rights Code, in particular Section 13, which talks about that you can't discriminate against someone in employment on the basis of there are 14 protected grounds. The common ones, things like race and religion that everyone knows about, but also age is a protected ground, sex is a protected ground, family status is a protected ground. So I think employers have to be careful when, honestly, at the beginning, when they're deciding how they're going to lay off people, that they're doing it in an even-handed manner. And also when you're bringing people back. And one of the things that's come up that I think employers should be careful about is, I don't think you should be looking at this COVID or temporary laying off someone as an opportunity to get rid of, that worker who doesn't fit in. Like, I think you're inviting a claim. I've already been made aware of at least one situation where was an older worker who was temporarily laid off while everyone else in that office was able to work from home, right? And it seems a lot like that this is an employer using this crisis as an excuse to try and shuffle off someone that they don't want there and get out of some of their perhaps notice or severance requirements. So really be careful about that. Maybe that's a bit late, but also when you're bringing people back, you want to be even-handed in general. I agree with Lisa, talk to people. You have to accommodate your employees on those protected grounds, but be even-handed. That's the main recommendation that I would make. Otherwise, you're inviting a claim under the Human Rights Code for discrimination.
Okay, so we actually had an inquiry early this week. A business was reopening. They had called back their staff. They had identified the PPE that the staff were required to wear as part of their, mitigation of risk, and 2 of their staff refused to wear it and walked out. Obviously, there's a fear factor there, but what would be a path if something like that were to occur?
So that actually, Jeremy, that's a problem, because requiring your employees to wear PPE to protect other employees, I think, is a very reasonable request, or members of the public, right? Particularly if you can't keep that 2-meter distance. And so that's back to my original point, that employees have a responsibility to comply with reasonable requests of their employer. So that might be something that is the cause of initiating some progressive discipline, because you can't have employees just completely ignoring reasonable requests. So, I think that employer should get some advice and should perhaps go and explain to those employees that, look, you actually do need to comply with this.
Yeah, I would agree. It is regulated under WorkSafe BC, so the employers have to comply with it. So it may require some education. I think education is, very important right now, because people don't understand all the rules, and it is very complex. So starting with education and helping employees understand the employer's obligation legally as well.
So Lisa, just further to that, because David's brought up an interesting term, which is progressive discipline. And some employers in the workplace don't really understand what that means. So can you maybe just give us a quick overview of what a progressive discipline process would be?
Sure. So progressive discipline really is varying steps that takes place prior to getting to termination, if that's the outcome. So I think you have communication. It usually starts with verbal communication, letting them know the expectations or requirements. You also let them know that you expect the behavior to change, or the performance to improve, or whatever the situation happens to be. And then if it continues, you might move to a written termination, and then, written letter. And then it might move to a suspension, depending on the seriousness of it, and then it might go to termination. So it really depends on, the circumstance, the breach of policy, or what happened. Some are, if they're so significant, might result in immediate termination because it's so significant. That might be, in healthcare, for example, when I worked in healthcare, it might be patient abuse, or resident, or, something like that, that there's zero tolerance for that. So it really depends on the situation, but it's basically taking steps, and you give the opportunity for the employee to be aware of their mistake, improve upon it, and correct it.
Right. Thank you.
I just wanted to jump in on one thing, just to people watching this just to be a bit careful. Employers don't automatically have a right to suspend an employee. So that's something you have to tread really carefully with, because unless that's actually in the employment contract, suspending an employee could be a constructive dismissal of that employee. And there's a famous case on that at the federal level. So suspension is something to be actually really careful with.
Yeah, great point. Thanks, David.